have.
Are we ready?
You can keep it, I don't want it back.
I'd like to call the Marvin Planning Board meeting of August 22nd, 2023 to order. We have a quorum. We are currently, I believe Michael Lavelle is online. I think I saw is online, but we are missing, let's see. Bob Markleese is not here. And who else are we? I think that's,
Oh, he did.
who is tomorrow? Oh, and then, yeah, so Bob's the only one. Ah, okay. Would anyone like to make a motion to allow Michael Lavelle to participate remotely? Just not Richard, because he's coughing to death?
I make a motion.
Oh, he did it anyway.
Michael to
Can we get a second?
participate
All right, all in favor? All right, so moved. Has everyone had a chance to look at the agenda?
Yes.
Any changes, comments, questions? Can I get someone to make a motion to approve the agenda?
So moved?
Makes a motion, and then you want second? Okay, all in favor? All right, so moved. And adoption of the previous minutes. Has everyone had a chance to read over the previous minutes? Who were here? I think you weren't here, right? Rich, you weren't here.
I wasn't here for this.
Oh, the end, yeah,
Sounds
okay.
together, yes.
If anyone would like to make a motion to approve the previous minutes? Thank you. Anyone second?
I'll second.
And all in favor? Aye. So moved. Everyone's mics on? All righty. I don't believe we have anyone signed up for public comments. All right, so moving on to our first item of discussion. Discuss and consider recommendation of special use permit application for a pool to be located outside the setbacks per the 151.054E located at 206 Claridge Court. Hunter.
All right, yeah. So this should be fairly quick, but in short, the village has received a special use permit application for a pool to be basically located outside the setbacks. Per our ordinance in 151.054, it has setbacks for pools, says 15 feet on the rear and side. And then it has a clause right under it that says in all other provisions, a pool that's located outside the setbacks can be considered for approval of a specific location with the approval of a special use permit. In short, this property is in Belgrove. It abuts a 285-foot view shed buffer. When it was platted, the rear setback line was not platted. The house had to be pushed back because of the way that to meet our ordinance requirements, the house actually does sit back 25 feet off the rear property line. The applicant's, wanting a pool. He is looking into trying to move the location of the pool to comply with the setbacks. That's why he's not here tonight. This is kind of just a procedure thing. His contractor was out of town last week. So hopefully that answer will be decided, like if we need to continue with the special use permit, but from a process standpoint, that's why it's on the agenda tonight, so then he can have that confirmed to me by the end of the week, and if so, you guys have already made the recommendation, and it can go to council in September. But in short, pull up the plat for you guys. So the plats, it's lot 27, as you can see. All the other properties on any of these plats have the rear setback line. When Empire came to get the zoning permit for the house, this was brought to our attention. Our attorney was, reviewed the the plat, what was being submitted, and basically came to the determination that since the plat was approved by the village with no setback line per se, and was supposed to be a developable lot based off of all other approvals that for their final plat, the construction documents, everything, that we had to honor the final plat, and they just basically had to push the house back to comply with the front setback, the minimum lot width, and the side setbacks. All of that complies. Like I said, the house just sits 25 feet, 25 feet off the rear. The proposal, let me get this pulled up, is basically to do a pool in the rear yard. These setbacks that is on this plat for this pool is not exactly where he's doing it. He is doing it a minimum of probably 10 feet off the side, off the rear, and moving it a little to the left. Myself and our engineer met out with the applicant to discuss kind of any type of grading or any other issues with the proposal. Everything's been cleared on that end, and in short, staff's recommended approval, and we'll answer any questions.
I have a question about, and I haven't seen this, the overhead, like is the common space mostly trees or?
Right, it's heavily wooded. And so the pool is going to be on their property. It's not encroaching into the common open space. No trees will be disturbed in the common open space. And you can't see this from the road at all. I drove past there today, and like I said, it's 285 feet of dense tree vegetation. And that's why staff's making the recommendation of approval, because it's abutting a, platted common open space protected buffer, and it's not like it's abutting another residential property.
So one of the things that I did see, though, that we were saying, I think in your write-up, that it was 5.8 or 5 foot 8 inches, and I think on one of the architectural renderings it was 4 foot 8.
Correct.
Not that that makes a difference, but I just want our documentation to be.
Yeah, so that's where, as mentioned, the applicant's getting that final location worked out with this contractor.
Okay.
For this sake, like I said, it's kind of the procedural thing. It's a special use permit. Our ordinance says that it has to go to you guys for recommendation, even though when council considers it, it's not supposed to be kind of taken into consideration that way. But so that's why right now it does show 4.8. When we met out with him, it's going to be at a bare minimum, I think, 7.5 feet off the rear. It exceeds the 15 feet on the side. It would just, because basically he would be putting the pool in and then doing like a retaining wall and then some basically landscape plantings at the back.
Right, say that again? Plantings, did you say plantings?
Landscape plantings, like the pool, and then have a retaining wall at the edge of the pool, because the property's sloped, like. So that landscape planting would basically be along, but within that 7 feet between the pool and the rear property line itself.
It's common space behind that, right?
Correct.
Can be built on, right?
Correct.
Okay.
One of the other questions I had is on all the drawings from the pool company, there's no mention of where the equipment is going. And my concern is that how's it going to be shielded? You got a neighbor on the north side of it. So I didn't see that here whatsoever.
So the equipment itself would be, I know these aren't like pictures of this property, but the equipment itself, it would be right here behind, tucked in behind the house.
Oh, well, not underneath that window where your arrow
Yeah,
is maybe on the ground.
It's either going to be like here on this side of the house or right here.
Right, so if it's on the side of the house, though, then the neighbor
There's a,
shielded?
it is, yes. Not for, yeah, the equipment's still going to meet the setback requirement.
True, but
But it's if you look here on the
I'm not trying to.
aerial,
No, I was just wondering where it's going to go. Because we already had in the pool company in Weddington Chase, and they moved it from behind the house to the side of the road. And they did a poor job of screening it, so now you drive by it and you're looking at the pool equipment.
This is a very, like, you can't, I was just out there last week. This is it's a 20-foot drainage easement. It's 10 on his property, 10 on the neighbor's property with heavy vegetation. None of that's going to be disturbed. So there's already existing screening, and also even from the road of the way that the property's angled, if you stand right here, you can't see the back of the property at all.
It looks like if in fact put on the side of the house right there. Oh, all right. It looked green to me, I'm sorry. Anyway, if the equipment's put on the side, it's actually going to be facing the garages of the adjoining property. It looks, just from the aerial.
It does look like that, yes.
You're talking about, so if it's here, you're saying
Yeah.
that, so the garage of this property is right here.
Yeah.
Like I said, you can't see at all.
I mean, it's not like.
There's a
it
tree
would be-
buffer, and like I said, the landscape plans, like, the special use permits for the pool location, obviously the equipment, if the special use permit's approved, the zoning permit would then be issued, and they still have to comply and show where that pool equipment is on their plot plan, and also do their landscaping as part of their zoning permit approval. This request is really just for the pool location itself.
No septic, it's all public, right?
Correct. It's water sewer. Any questions? Basically, staff's just requesting for planning board to make a motion for, recommending approval. I'm not even, like I said, 100% sure if it's going to go to council. This is just kind of a procedure thing. For the council public hearing, obviously, if it does get to that point, we'll have that site-specific plan of the actual location of the pool, the distance from the rear property line. So if council then grants it, that's what's being approved.
Questions?
So we're talking about a minimum dimension here, and it may in fact ultimately be more than this setback?
Yeah, I think that's why I put the 5 feet in the thing, because it's gonna be a minimum of 5 feet off, but it's most likely going to be more. Because I think that I think building code minimum is 5 feet. So it's at least gonna have to meet that even from a building code standpoint.
Anybody have any other questions, concerns before we move it to a vote? Would anyone like to make a motion to approve or, I guess, deny? I don't
I'll
know.
make it a motion. Make a motion to approve the special use permit
It's
2023-3.
recommend approval.
Recommend approval to the village council for special use permit 2023-3.
Do we have a second? And all in favor?
Aye.
A deep voice of God like, coming in.
Hello, everyone.
Hello, Michael LaBelle.
Morgan Freeman?
All right, so moved, and moving on to item number 2, discussion of Marvin Development Ordinances, our MDO project. Take it away, sir.
Wow. Bear with me, I'm just reeling right now from that process.
Hence why we're having it rewritten.
Unless that comes up again soon, that should be the last time that kind of thing ever happens. Just to give you a little bit of a refresher back, your ordinance calls for you to send a recommendation to the governing board, but state law prevents them from considering it as the foundation for their decision. So, you see what I mean?
Because For the because it's special use permit being quasi judicial.
Yeah, they're.
That's why.
Yeah, and secondly, something that I want to ask, because I am a few months ahead of you in my work as to where you are in reviewing the work, as you know. So I have a question. How scary are swimming pools to everybody here? Is that a terrifying event in town? Okay. Special use permits should never, ever, ever be used to reduce a standard, okay? Which is what that essentially, that process was put in and your old ordinance sets it up that way. So you're not out of bounds on that. Your ordinance sets that up, but that is not the intent of a special use permit. The intent of a special use permit is to make sure that they meet, based on evidence, all of the requirements in the ordinance, and then address any additional concerns that need to be added to that, not to go the other way. That's a variance. That's what that is. That's a variance. So your new ordinance draft will either A, not have that kind of procedure like that, or B, it will after you run me off. Because that's not only there are issues with the statute, it's also bad practice to reduce things. Special use permits are for them to prove that they can satisfy the evidence on a terrifying event, a cell tower, a solar farm, whatever scary things are to your community, not a fairly normal thing. That would be a variance. You'd have a normal setback for the pool, and if they want to reduce that, they apply for a variance, demonstrate the hardship, which I think in this case, it looks like it's all there. All the ingredients for that to have been a variance process under normal circumstances would be easily met by the review process on a variance. So it's like you went the long way around on something that didn't need that long way around, but that's what your ordinance calls for. So Hunter doesn't have any choice on that.
I have a question.
Sure.
Would you consider that a hardship, or would you consider, I'm just playing devil's advocate.
That one is a hardship because when I look at the facts on that case, I'm going to give you an example. That one is a hardship because, first of all, it's a cul-de-sac lot, which means that your lot width typically has to be recessed because as you go around that cul-de-sac, you can't get the lot width at the street front like you could on a straight stretch or a softer curve. So that's issue number one, that there is something that's kind of beyond their control. That homeowner that might have bought that home and decided to put in a pool can't change that. And that lot width being measured the way it is forced the house back further, which tightened the building envelope. So there's a number of little pieces to it. And it's okay, it's not wrong to know. It used to be considered wrong to buy property knowing it had a problem and then ask for relief. And the statutes have addressed that, saying that is not an ineligible consideration at all. You know, if I go buy a property like that, love the house, it's on a cul-de-sac, but I know it's going to be tough to get the pool in and I'm going to have to apply for a variance, that's actually okay because the circumstances are still there. Keep in mind, all approvals, you're not granting a developer approval, you're not granting a homeowner approval, you're not granting a variance to a homeowner, you're not granting a permit to a homeowner, you're granting it to the property. The homeowner or the property owner benefits from that approval or that authority, but all of these things in here run with the land. Save and except the fact that you have development agreements, which still run with the land, but they do fish hook in people a little bit more.
Yeah, that was important for me because it takes the subjectiveness out because it's rendered to the land.
That's right.
And not the person.
Right. You remember when I first met you all, I gave my reenactment act there, and I said, well, you know, Hunter's family's always been real good to the town. You know, they dedicated an acre over here for the park and everything else, so we're gonna give them their approval. But old Rick here, he's a scoundrel. He used to jump his bicycle through my grandmother's rose bush delivering his newspapers, and we're not gonna do anything that family wants. That's over. All that's over. Statutes cleaned that up really, really well in 2019.
So there won't be an opportunity for someone to say, well, a pool is a luxury, you know, it doesn't meet the criteria.
Nope, it's a right. They have the right to do what is in your ordinance per that district, per those standards, per these specifications.
Because there's an ordinance for.
And there's a process, and in those unusual circumstances, there are processes for hardships that result from circumstances. The shape of a lot, a creek eroding closer and closer, you know, things like that, because you should have the fair and reasonable use, or what's referred to, and I'm not an attorney, so I can't give you legal advice, but what's commonly referred to as quiet enjoyment of your property, which means I can put a fence around the backyard, I can, you know, put a pool in, I can do things. I can do things.
Thank you.
And so I asked that question of you a little while ago, if you're scared of pools, because normally I reserve special use permits for only the terrifying issues, the things that warrant evidence, because that's an evidentiary process. And so when Hunter mentioned a public hearing a little while ago, it's actually a hearing of people with standing only.
Yeah.
Not the public. So somebody from the other side of the neighborhood can't come in to the meeting and say, well, you know, I want to say something against it. That they actually don't have standing, so it's only people with standing, and that's defined in the statutes as well now. Which is kind of a good thing that they've narrowed down the quasi-judicial, so it's not a big public thing. It's about the people involved, and that's really what it is. Legislative things, that's a big picture thing. That's like a rezoning or a text amendment or whatever the case may be. Those are still pertinent to the community as a whole. So thank you for letting me digress a little bit there. Tonight should be, I don't want to jinx it, but should not necessarily be a lengthy meeting, because when I kind of compartmentalized in the reading guide which ones would roll out when, this happens to be one where we have a fairly simple batch that we introduced last month, because they're that mandate. And for our returning member, I don't want to call Mr. Jones a new member, but for our returning member, I hope that you've got a reading guide in your notebook that they prepared as well. So all of that stuff up front is that what I call boring, the administrative and procedural. Largely, we get guidance from the statutes on that. The mandates are what we introduced at the last meeting, and then they're up for review now. So if anybody has any comments, but before Madam Chair, before I actually ask for those comments, keep in mind the flood damage prevention ordinance, the only thing we can do is change the number of certificates and the amount of the freeboard. That's it. Freeboard, that's the distance between the top of the flood water, if it's up to my knees, and I'm standing beside my house, the finished floor of my house needs to be, by federal standard, at least 2 feet above. They're now recommending 4 feet above that point, because what used to be referred to as the 100-year flood, which is actually a 1% flood, you may have a 1% chance flood occur 2 or 3 times a year in some situations now. And this has really been driven hard by risk mitigation, with FEMA and the Dodd-Frank Act pushing against each other to reduce risk, mitigate risk. That's where that comes from. So 2 feet is a minimum required for the town to remain in the National Flood Insurance Program. 4 feet is what I recommend that you consider, because as you develop, you're going to see that become more of an issue. Even if the floodwater doesn't get inside a house at 3 feet or 2 feet, it's still going to be on things like floor joists and what have you, which can be damaging. So I strongly encourage you to consider the 4, which is becoming more popular now. You know, that people are really factually trying to mitigate some of the risk to loss. So without further ado, all 39 pages, free board and number of inspections. I recommend all 3 inspections. People say, well, doesn't that cost more? Yes, it costs more, but if you catch it early, it actually costs less. If there's a mistake on the what's called elevation certificate that goes with a flood. Anybody building a building in a flood-prone area, they either have to demonstrate openings and that finished floor elevation, or they have to demonstrate how it's been flood-proofed. And both of those are extreme, well, the flood proofing is much more expensive than just raising, typically. The first elevation certificate is at the permit time, where you're showing, here's the flood information, and here's where the finished floor is gonna be, and this is what our surveyor has been able to confirm. And then the second one is after the foundation is poured, that they've got that done correctly before they start vertical with the house. And then the third one is upon completion, to make sure that any backfill and everything around the house didn't change those dynamics. That's what's in your draft right now. You can reduce that. I don't recommend it, because it actually saves them money to check along as they make progress on a project. And I know with the, value of homes and things of that nature, that can be an expensive proposition, should you cut that corner or make that mistake. So that's why that's in there as a recommendation. The other thing you can change is who administers your flood ordinance, whether it's your stormwater person or your planning person or something like that. Would you prefer that to be appointed by the council or by the manager, that position? Flood administrator, floodplain administrator. Is that you, or is that your stormwater person?
I'm both.
You're both? Okay.
I would probably say the manager will be fine.
That's what I've
because
got in the draft.
I think,
When there's a manager form of government, I normally have the manager do the appointment.
yeah, because we are growing, like we just hired a public works director, like that would then give her the authority to potentially, appoint have that person, a potential person within that department either be stormwater or floodplain other than me, instead of it having to go to council.
So if you were to say we've got 2 for certain height, if we as a village were to say it would be less, could that potentially put the village at risk?
Only if it's below, if it's below 2, you're going to get kicked out of the flood insurance program, which is going to severely affect people if they have to have a mortgage, because it's federal law. If you have a mortgage and your property extends at any point into a flood-prone area, that you have that insurance, even if the house could be up here, if that lot goes into it. So you'll see as we get to Article 16 how we start to use a lot of common sense in this ordinance to make it easier to set people up for success, not failure. The floodplain, that's still going to trigger insurance. You're still going to, there may be a risk difference. Okay. Okay, that's not my understanding, but that's Terry Fox. Okay. I'm with you. So, all right, so touching the house, we'll go with that, touching the house. Now, back to this question about what happens. If it's above 2, you can set it. If you want to do 2 or 2.5 or 3 or 4 or whatever, you can do that. Now, as to whether you are exposed in any way, that's a question for your town attorney. I think as long as you are complying with the federal requirement of minimum of 2, you're safe from that, but that's not a legal opinion. I can't give you an opinion on liability on that, okay? But if you increase it, you are probably helping more because you're moving those floor joists further away from the surface of the water. In a 1% flood event, which we normally get in certain watersheds or creeks and things of that nature fairly commonly, If you've got a 2-foot freeboard, you've got joists that are gonna be 10 inches or 12 inches above the water, which is problematic from a mold standpoint and other issues. I recommend the 4. You may decide to go with 2 or 3, but I do want you to let me know at some point if you want to change the draft from what we have in front of you right now. There are some dates in here that I've got to confirm. That's what the green is. I've got to get that from Milton Carpenter and Terry Fox and Aaron Fennell. Those are the 3 people that administer the state of North Carolina through the Department of Public Safety in Raleigh. They're sort of the liaison directly to FEMA on those matters. So I always have to send this in. So to them, that's why that's green. The green is I know I've got to change it. I know I've got to change it, unless you gave me those days. I don't think you gave me those days. So July 3rd, 78, you weren't even incorporated then. But the initial firm map at the time might have been somewhere around that range. I think I snagged those dates from Stallings because I wrote Stallings ordinance a number of years ago, and I had to get that data from them then, so I think I stuck that in there, because normally they'll release firm maps for like a county at a time, but I'm gonna get, Aaron will actually be the person to confirm that. So the green is definitely likely to change. The yellow is stuff I want you to look at. That's what those choices really boil down to, okay? Page 10, which is in some definitions that they like to have inside the flood section, is where the 4 feet appears. Okay, you'll see it highlighted in yellow. Yeah, I'm gonna go look that up, Mr. Owens. I want to check into that, because I was a certified floodplain manager and went through all the courses and the training and everything else, and that was my understanding, was on that. Okay. I'll let y'all know. I'm gonna look too and just make sure that I'm telling you right. It's more about me making sure I'm giving you the right
And
information.
I'll mention too, well, I'm pretty sure Rick's right on that, because we just had a floodplain, because they redid the floodplain maps, and I was doing some research on it. I'm pretty sure if it touches the property, you have to have you have to have insurance on it.
If there's a mortgage,
Correct.
if there's a mortgage.
If it's the lot, because when you get a mortgage from a bank, they're issuing it for the land and the building.
I don't know. I'll check into it. Any other comments about 18? Mr. Jones, this is the hopscotch that we're playing, so at this meeting, we're sort of talking through stuff that we introduced last month, so you had a month to read those, and then in a little while, we'll introduce stuff that will then be discussed at the next meeting. Okay, perfect. All right. Okay, can we move on to Article 19? Stormwater management. All 3 of these are all wet stuff. 18, 19, and 20 are all water. And our mandates that come down from Washington, D.C. have decided to compartmentalize water. So instead of having one consolidated policy, we have flood, stormwater, and soil and sediment control, all in their own separate little buckets. What you're looking at in Article 19 is going to look extremely familiar to many of you. The only changes from your current, this is your current, is the yellow. And on the first page, of course, there's a lot of yellow because your old one really didn't set the tone with a purpose statement. You always need to do that when you start a set of standards or rules, is you state why it's important, because that, if it's ever challenged, is going to be critical to defending it. So you can see wherever there's yellow, that's where I have adjusted it to fit into this new development ordinance. Okay? So there's no change in policy at all. None whatsoever. All right, Article 20. This is the construction phase stormwater stuff. That last one in 19 is really what, after the construction's over, what is the stormwater facility doing, and year in, year out, forever and ever and ever. 20 is during construction when they've got a big mess out there, and they've got to do the sediment ponds and sediment basins and all that. And I always like to make sure that the town has, even if it's being done by another agency, state of North Carolina or county, for you, that you have a base level presence in that arena so that you do have eligibility to issue stop work orders or something like that, because there's an attorney somewhere around here, the Murphy Law Firm, Murphy's Law Firm, and I think it's got a zip code somewhere in this area. So you know when you get that big rain on that construction site, it's going to be around, what time do you close on Fridays? We're not on Fridays. It's going to be on Friday. It doesn't even have to be 5 o'clock on Friday in Marvin. It can be any time on Friday, but that's when it's going to hit. And somebody's going to call town hall and say, oh my gosh, it's all running in my garage from next door where they're building a new house. And, you know, and if you answer the phone, you have two choices. Either one, yes, ma'am, we'll take care of this right now, thank you for calling, or that's not our jurisdiction, you need to call the state or the county. Now, which one plays the best with your village council? Right. So I always like to put this little skeletal piece in here that basically ties in what that other agency is doing to your ordinance, so your administrator does have the authority to, he's not reviewing the plans for that, that's still their job, but he can get somebody's attention real quick and institute penalties and fines and, you know, get somebody to address the problem. That's why I do it that way. That's why it's only 2 pages and a pinch long, because it doesn't have all the design criteria in there for it. This is really about being able to respond to a failing situation, a failing system. Typically at 5 o'clock on Friday, but here in Marvin, it could be any time on Friday.
Is 20.1-1, is this language from the state or federal? Is this just?
This language is generally from a full-blown where the town actually does their own. I just stopped talking after a certain point rather than adding all the standards into it, because some larger jurisdictions actually administer their own program, so that's where this is from. This is from a bona fide soil sediment erosion control ordinance. We just acknowledge that the standards, the plan is for that is actually approved by either DEQ or the county, depending on what your relationship is to them. By default, it's a DEQ, State Department of Environmental Quality, okay?
But is the 1 acre threshold, is that a state?
Yeah, that's state. That's state.
And is
That's everywhere in North Carolina.
Is that 1 acre for, what if you own like multiple properties?
That's a 1 acre of land disturbing activity. It doesn't matter about property lines. If you go out and you take a bulldozer and you just start making a big mess, whether you got stayed on your property or whether you got on somebody else's property, it doesn't matter. If it's a contiguous acre of disturbance, and disturbance is
Wait,
really pushing
A
stumps.
continuous acre of disturbance?
Contiguous. In other words, it's
Contiguous,
together.
okay.
It's somehow
Yes.
together. It's not an acre over on this side of town, and then they went over there and did another half acre over there, and we put the 2 half acres and call it an acre. No, it's a contiguous acre, but what a land disturbing activity is too, just so that you know, if they cut trees, that's one thing. And we deal with that in another article altogether, cutting trees, okay? Land disturbing is when they go back in and they start pushing the stumps. They're pushing up topsoil, they're pushing stumps out of the ground, they're literally disturbing the ground cover, okay? Because the factors that contribute to runoff are really when the soils are exposed. When you've got ground cover, or you've got trees, or you've got grass, or you've got pine needles, or whatever, generally speaking, you're gonna be able to retain the soils. You're not gonna have the erosive nature of the soils. It's when it becomes bare that if you're stripping off the grass, you're stripping off the underbrush or the stumps or whatever it is, or some combination, that's when it triggers this. And that's state law.
And is that what we currently have now?
Yes.
Question.
Yes, sir.
Some guy owns 20 acres or whatever,
Mm-hmm.
and he goes out there and he grades 9/10 of an acre this year, does whatever he's gonna do with it. And then he comes back next year and does another 9/10 of an acre, and he keeps,
That's not gonna trigger the soil sediment erosion control.
Yeah, that's-
It's not gonna trigger that. It's gonna trigger something else, though. It's
Well-
gonna trigger development without a permit or whatever the
well,
case
I
might
mean,
be.
assuming he got a permit or whatever.
Assuming he has a permit there,
Yeah.
that's fine, but yeah, 9/10 of an acre, because typically what you would do, let's just pretend that this is a project that's being phased. I'm gonna build a house, and I'm gonna build I love the hobby shop that I witnessed in here one night with all the cars and all the cool stuff in it and everything else. They're gonna build that, and then they're gonna come in and they're gonna build a place, for the horse barn or whatever. They can do that in phases and piecemeal without disturbing, as long as they don't disturb more than an acre, and then reestablish, restabilize. They might plant grass, trees, some combination of landscaping, hardscaping, whatever, and then they come back. Yeah, that's not a problem, as long as they're doing it with a permit. That they have obtained a normal zoning compliance permit to build the house, to build the barn, to build the swimming pool, to build the toy hut, whatever it is. Okay? So that's the 3 that I introduced that very first night as the really, really, really boring stuff. The federal mandates. Those 3 I put them into their own little grouping. They basically are things that we inherit, that come generally from Washington, come down 95, turn on 64, get over to Raleigh, and Raleigh says, we do not want to touch this stuff, so we're going to give it to the localities. So they send it to us, and what have you. So, except soil and sediment erosion control, they don't mind doing that, but they want us to do all the hard stuff. Okay, that went pretty easily, I must say. Let me now, Madam Chair, if I may, I want to move on to the introductions for the evening. This is kind of a big deal right here. It's a little bits of paper, but it's a big deal because it represents us moving into the character grouping, the character elements of an ordinance. This is really the first, and so I start kind of light on this character topic, the character of building your town or completing your town or the evolution of maintaining your town, whatever state you're in, of completion of building your community. It's all about the character. In this particular aspect, generally speaking, we've got a lot more leeway in setting standards. There are certain things we can't do, and I'll always point those out if we get to that topic, and if somebody asks me a question that triggers that thought, okay, I'll always point to where we do have our hands tied, because there are a couple of areas that they have tied our hands. But generally speaking, the standards and specifications are pretty much where you've got a lot of wiggle room. And we'll talk about those in the not-too-distant future, the ones that you've got issues with. But I start with Article 2, and it's numbered Article 2, and sits up near the front of the ordinance for a reason. Because most folks that live here probably already have a house, right? So let's just think about that for just a second. Y'all already have a house, right? Yourselves, right? But you might do something. Let's say you want to put in a pool. You want to do an addition. You want to do a deck. You want to do a hardscape area. You want to do a pool house. You want to do a third car garage, whatever the case might be, you're going to be thinking of these other things, okay? And so this Article 2 is really a great bucket to throw those things into, because that's where you can find things about walls. And I'm not talking about a wall of a building or the wall of a house. I'm talking about like a wall that might go around your yard instead of a fence, or even fences. And controlling or establishing standards for what those materials may or may not be. I'm going to use an extreme example, you know, no razor wire in the neighborhood, right? A lot of people think, well, why did you even put that in there? Nobody would do that. Well, I can show you some pictures of crazy stuff people have done because something didn't go right for them and they reacted however they reacted. So we put the standards in there. You may never need it, but the day you do, if that tool's not in that toolbox, and they call and say, listen, my neighbor put razor wire on the top of their decorative vinyl fence in the backyard around their pool after they caught those kids swimming in there last weekend, and that's dangerous. What can you do? What could you do today, Hunter?
Well, we actually do outlaw right now with fences of the material. So if that was to happen, it'd be a code enforcement violation, I'd have to remove it.
Perfect. So you're already doing this. And so there's going to be stuff in there that you're going to want to look at. Material, you know, what types of materials are okay towards the front. You might have certain things in the back that you don't want in the front. Chain link or whatever. Do you do any chain link, and is that in the list of prohibited? Is it okay? Is it limited to rear only, or is there any?
Trying to think. I wanted to say we did regulate the material.
Anything in the front particularly, I would think.
Well, we regulate height in the front. We regulate height. I think like
Height.
the maximum
There you
height in
go.
the front
Right.
says within the required rear and side yard, the maximum height of the fence shall be 8 feet. And then it says within the required front yard, the maximum height of the fence shall be 5 feet.
Yeah, very consistent with what I've got prepared for you. Okay? And it's a little bit different in non-residential areas where you may have a need for that. You may have a dumpster screen wall or something like that at the restaurant or whatnot someday. Okay? So we've got that stuff in here. So Article 2 really marches through a long list. It starts out, though, by pointing everybody to the appropriate thing. So new development in Article 2 is going to have to hit the uses, the building standards, the landscape, the parking, the streets if it's a new subdivision, sign standards, all the different things that go normally, but then it jumps into a lot of that general bucket, general requirements, we like to call them. Remember, the green highlighting is stuff that's going to change. And we use a lot of graphics in here, so I want you to just sort of read through this, ignoring the green. But just sort of read through this over the next few weeks at your leisure And then you'll be able to come back to the meeting with questions or comments or recommendations or concerns. And remember, this has a little bit of everything in it. You may decide you want to take something out, okay? That's okay. I might tell you why it's in there, but it's okay to back away from something. But if I don't show you what it, draft language on these various topics, then it may raise more questions than it answers. So I'd rather answer more questions.
And Rick, can I just clarify, so the stuff in like the green, like the districts itself?
Yeah, ignore that
We'll
because
circle
we've not
back to
even.
when we get to the districts, like in this, like when we
We'll
get
be
to.
dealing with districts
Yeah.
later on. Yeah, that's why I've got that in green, instead of me going in and putting a blank in there and what have you. No, I'll fix all of that at an appropriate point in time. But this comes out of, I basically build a robust backbone, and I start there. And then it starts customizing wherever you are for whatever it is you want to accomplish.
Can I, Hunter, can I ask a question about on the back of page 1, letter C, up to 4 residential lots may be served by a private street, meeting the standards for public streets set forth in the village, technical standards. When we were talking about that one, like landlocked property, there's a landlocked property behind me that, no, that must be something else. But, so, my question is, like, if someone has, either 1 or 2 parcels that they own off of a main road, and they want to do like a small development in there, can it be served by a driveway, or does it have to be served by a private street meeting the standards?
If you continue on through this list through F, you'll see that there are some shared driveway situations. Okay, E in particular on the residential side. Okay, and we'll sort of walk you through a little bit of that, what that might look like. Commercial can be a little bit different than residential because I'm gonna dumb this down a little bit. You ever been to a mall? Did the mall ever have a restaurant sitting out on some loop around it like Concord Mills Mall does, or Carolina Place Mall does, that doesn't actually front on anything except 485 or whatever? You can't get a driveway on 485. So we deal with this all the time in very conventional development, even though it's easy to start thinking landlocked lot, how do I develop or build on it? How far can I go? And that's where we set the standard. You may say, well, we want to let them do 40 lots without putting in anything but a gravel 1-lane driveway. And you may say, we don't want that at all. That's where I need to hear your feedback. This is your starting point, so you can see what it looks like to capture the issue on several. So right now, the way this is written, if you're going to do private streets, and you've probably heard me say this before unless I'm having just a deja vu moment, you'd be crazy not to require them to still build it as a public street standard. And here's why. I'm gonna put my reenactor hat back on, remember? A reenactor. And I'm gonna come in here to one of the meetings on public comment one day, and I'm gonna say, I've been living there 25 years, and I've been paying my taxes for 25 years, and we live in a gated community, but we pay our taxes just like everybody else, and we want you to come out there and fix our potholes. Well, the only reason they want to do a private street is to not build it to standard, which means it's going to fall apart faster, and then they're going to come and say that. They're going to do it.
And
I'll bet you.
to add, so when we did the gated subdivision private road, if you recall, in that text amendment, I specifically put that if a private road is to be, as part of a subdivision approval or a subdivision proposal, that private road still has to be built to our standard. There also has to be a maintenance agreement in place before the final plat is approved to make sure that it's clearly identified that the HOA or some entity is responsible for that. So we have that covered in our current ordinance, and if we want to continue allowing private road, because right now our ordinance we changed this allows for subdivisions to be a private road if it's just a single ingress egress road, basically, because then it would allow for if they wanted the gate.
Right.
But we did require them that to have it, they would have to be to standard, be, reviewed and approved by our engineer and all that. So that is covered in our current ordinance, and if that's something we want to continue doing, obviously we'll make sure it gets put into this.
Right, and we can put that in there, but I still I agree with the recommendation and what you're doing, and that's what this is basically doing, but I generally approach subdivision as all streets are public streets, okay? Because they're going to come back to you at some point. Anybody ever heard of Carolina Panthers? One of the Panthers came to me back when I was under my non-compete agreement, and I could not do governmental work. I could only do private development work. And he had been approached by a bank to bail out of a subdivision that was struggling, and it was not only gated, but literally had an archway over the road, all stone and stucco and all kinds of stuff. Guess what? It's gone now. The centerpiece is gone, it's public streets and everything else. Because we went in, we did some testing, the streets were garbage, and only half the homes were built. And so that was a very valuable lesson. I talked him out of it. I said, don't touch this with a 10-foot pole. The bank saw him as being able to bail out the previous developer. I said, don't do this. And if you go by there today, 15 years later, there is no arch. Whoever ended up with it went down the proper path. So private roads sound good. Where I live in Kannapolis, we have a very well thought of gated community that's been gated for about 20 years, that's spent the last 10 years trying to get the city to accept the streets. And it's where a lot of professional football and NASCAR and a lot of lottery winners. We've got 3 lottery winners, big lottery winners that live in that Pine Creek. And, so the smallest house in there is like, I don't know, only 10,000 square feet, something, it's just tiny. And yet the development was done on a private road, and the streets didn't last 5 years. So if you want, so let me just ask you this question. How do you feel about future gated communities, more of them? You okay with them? You like them? You don't care for them? They've been a problem? What do y'all think? Kind of a straw poll. Any thoughts? Anybody live in a gated community now? Any of the members in here? Private road, no gate?
Yeah, his is a mess.
Yeah.
It's a legal
I live on a
mess, too.
private road as well, and it's a mess. It's falling apart, so.
That's why I don't have the provisions that you've got in yours now that say we can do this. I can put them in there. Normally, I just don't even put them in there,
to
but I can
add-
put them in there.
In planning boards, from a very little background, our ordinance previously did not allow private roads. It didn't allow gated subdivisions. The request came because there's one neighborhood that's existing that the roads have not been petitioned and accepted by the village. That's a whole nightmare in itself. And they wanted to do, it's a 12-home subdivision, 1 ingress egress, wanted to do a gate, and then we had another subdivision that's going through the approval process that wanted to do private roads and gates. Consulted council, and council basically said that, if it's an existing subdivision, that if all the property owners agree to it, then we have the existing subdivisions as special uses. New subdivisions can be gated in private roads as long as that is part of their approval at the time of the subdivision approval. But yet both standards are the same. Private roads still have to be built to our standards. There has to be a maintenance agreement in place. But the reason we kind of did it for the existing that way is that we want to make sure that all the homeowners know what they're getting into if they're taking over the roads. And plus, at the end of the day, to your point, we want them to be built to our standards, because a gate sounds great in theory. If they come and get it, who's to say in 5-10 years they don't want it, or they're hitting a point where those roads are still at standard, but there's some repairs and stuff that need to be needed, then if we know they're built to our standards in the first place, and not in terrible shape, then that's something they could take down the gate, petition the roads to the village, we'll take them over and get them maintained.
There is one situation where that's already in your drafts, okay? You haven't seen those articles, it's a little further down the road, that would allow it without it being in this part. So let me describe that to you. When you go to a shopping center, you're typically inside on some private circulation, you know, over at Carolina Place or one of those places. You've got the little loop that goes around. All that's part of their internal network, yet they've got properties in there, out parcels in there where the restaurant may own the building or something along those lines. So there is this other thing that's not a subdivision of property. It's called Planned Communities Act. Qualifies for the Planned Communities Act. We think of all communities as being planned, so it's a terrible name to have in the statutes, planned communities. Every subdivision's planned, right? But they called them, in the original act, Planned Communities Act. So if we jump over here on, go down through Lancaster, or towards Lancaster, okay, go down past the state line and everything, we have this thing called Sun City. Anybody seen that?
Yep,
Is that a subdivision?
it's a planned community.
Here's a hint. Here's a big hint. It's not a subdivision. It's a planned community. Not quite a PUD. It's a planned community. Now, what that means, and my sister-in-law lives in one in South Carolina. The grass is not yours, but the house is. So your lot lines are essentially going around your chimney and your patio and up by your stoop and the steps and back around to the chimney. And so your driveway is not yours. Your yard is not yours. All of that is one parcel. Those planned communities are exempt under state law from subdivision regulations. They can do the streets throughout that community because that's no different than that little loop road that runs around inside the Carolina Place Mall or the Concord Mills Mall. That's what that road is that takes you to those individual homes. Okay? So if it falls under planned communities and it's therefore not subdivision, it's essentially a private pathway for vehicles. And in fact, there's a bill right now dancing in Raleigh, right now in the current session, that is trying to say that we can't set standards for those roads, that they only have to meet the DOT standard and we cannot require it to exceed the DOT standard. And it doesn't even have to meet the DOT standard if the project's engineer is willing to just sign the plans. Doesn't mean they're saying that it meets anything, they're just, I'll draw it and I'll sign it. And therefore, we can't touch it. Have you seen that? It's hot right now. And the way it would, a lot of people are thinking parking lots and stuff like that, but for me, what I saw that would affect the most people would be planned communities, like Sun City, where they could just put in that street and, you know, they could go out there and spray paint the grass and call it a road, and that's it. So that is one situation. So in my book, the only gated type of community realistically should be in that scenario, planned community. So they can gate it if they want to, whatever, because it's one big piece of property. So it's almost like your house is kind of a condo, sort of.
That's what I was thinking.
Does that make sense? Your house is kind of a condo, even though your house is not touching the next condo, there's grass between mine and Hunter's units. That is exempt from subdivision regulations, which are the foundation for establishing that new subdivisions have streets that meet standards. And that has always been exempt.
We don't even allow planned communities.
You can't not allow them.
Well, based on our one acre by right,
It's still, but what he's saying is still is like, if it's proposed where it's like, then I guess the question would actually be, because when you say like town, because I'm thinking, yeah, condos, townhomes, like you're.
You're talking about a house next to a house, and each
Correct.
of those are all you own. You don't own anything outside those walls.
a lot of, Florida has a ton of them.
Sun City. That's all I got to point to, Sun City.
But that's a, but it's, that's still its own individual conditional zoning district.
I'd have to look back at the act to see if there's a threshold in the act itself, because I think there is, but I don't remember it off the top of my head, because when that, they went away many years ago. You didn't see them anymore until, not up in the Carolinas. You might have seen them a little bit, Litchfield's got a little bit of that, what have you. But generally speaking, maybe Hilton Head areas and things like that, but generally speaking, you didn't see them until Sun City started moving inland with their retirement targeted community. So anyway, I don't want to get hung up on that, but that is the one situation where we really can't control that unless we are getting bogged down over, emergency response vehicle access, things of that nature, which we will. We will get bogged down on that at some point in a plan review, but planned communities are exempt from those subdivision standards that require a number of these factors, particularly around street construction standards, okay? I don't call them out in here. I don't encourage them. They're just stated that they're exempt under the same thing that state law says they're exempt, okay? And I actually have that right here. This is your state statute right here.
I do have just one question on that. I'm trying to think how to phrase this. Because when you're saying exempt from subdivision, just plain hypothetical, if the house, once again, if you just own the house itself, wouldn't that house, quote unquote, still have to comply with the minimum lot regulation?
Well, it's one big lot,
Then how does, okay, what about one
Density.
principal building
density.
density? I was gonna say also, what about the
Set
one,
density.
okay,
The one principal structure is typically viewed on a lot, and there's not a definition of lot versus parcel. We all view a lot as a small piece, and we view a parcel as, could be anything, could be 100 acres. But generally speaking, those planned communities are able to circumvent a lot of what we do here. Do you see one? I don't see one coming here, because normally your planned communities are targeting large numbers. We had some friends of ours move to one in Arkansas, actually. I was trying to remember what state they moved to. In Arkansas. Say the name again? Yes. Yeah, they've moved over there, and that's a planned community. Yeah. They're huge. And y'all really don't have that vulnerability here, okay? But I just wanted to point to you that there is that thing out there where gated might come into play, okay? Litchfield's got a lot of that, We have a place at Litchfield, and we go through a gate, and we do all the stuff, and we pay for all the niceties and everything else, and we love the fact that we don't have to touch anything outside, you know, the home. Well, they can make their HOA dues tax deductible if it's a property tax.
Hunter, you said our current ordinance needs 100% of the residents to agree to a gated community if they are choosing a gate. Yep.
And that was done because, once again, council felt like, once again, if all property owners can agree and sign the document, so be it. I mean, once again, it's not that we already own the roads anyway. I mean, it's privately maintained, so it's just kind of an extra checks and balances, once again, that you don't have a majority of the property owners want it, and, you know, if you have one holdout, then you're not getting it.
The biggest problem with those is when a home sells and the new owner doesn't learn about the obligation until after they've closed on their home. You know, they sit down at the closing table and they're having a great time with their ink pen there.
Well, and I think in our ordinance, once again, part of the, like, special use, part, like, some of the evidence to be considered for this is, once again, if it's an existing subdivision that's private roads, is that they have to provide evidence that it's a maintenance agreement's in place and that their CCRs have been amended, all this stuff where, once again, we can't regulate that, but it's evidence provided that, hey, these standards have been, you know, put into place, so that it's kind of, once again, we're trying to make sure that, hey, if this is the route they're going, we're trying to protect the current homeowners as well as future.
Yeah, I've thought and toyed with in the past requiring a posting of the neighborhood so that there's an information panel that says, you know, welcome or whatever, private streets, privately maintained by HOA, and dues paying HOA members, et cetera, so you don't miss it. Because so many people, and when we talk about fences and all that other stuff that's in Article 2 here, we'll come around to that at some point, probably next month in our review, where if you were out talking to a fence contractor, chances are you're not going to have your plat in your pocket, where you might ordinarily discover that there's a utility easement like the one that you were talking about in your special use permit earlier tonight that ran between two homes, things like that. So we try to set everything in the ordinance up to where those don't become obstructions to normal things like fences and swimming pools and other stuff that somebody might do in their home. So anyway, that's what Article 2 is about. I do want to call your attention to a couple things. These are very
One quick
important.
question. What if it's mixed cities within the same,
If it's,
mixed cities, two different cities in the same subdivision?
then it's where the event is taking place.
Okay.
Unless those two jurisdictions have worked something else out. I don't like working something out. Sometimes your assessor's offices they will decide that, well, instead of prorating the taxes, we'll go by where the house is. I can even tell, I won't name names, but a county that has a written policy that it is where don't shoot me, master bedroom is located, is who gets the tax, is where they pay taxes. Primary now. No, I'm talking about what their agreement says. Yeah, no, I'm not being politically correct. I am telling you what the agreement between these jurisdictions says, and I'm like, you gotta be kidding me. And they're like, no.
I'm concerned because I live on a private road that's in Waxhaw. I have 2 homes that are Marvin, mine, and 3 homes that are Waxhaw.
Both in town, all of them in
just
town
one-
limits, right?
They're in unincorporated Union County.
So it doesn't matter.
Yeah.
Well, it's the same thing. Now you're in
Still-
municipal and county jurisdictions. Yeah. So it's the same situation, yeah.
Yeah.
But it's basically, you know, the line is where the line is. And we'll be talking about district boundaries a little bit more later when we get to districts. But if you want to go back to Article 1 and rules of construction on boundaries, on how to interpret zoning boundaries, it will give you a little bit of of insight on that since it affects your property like it does. Those boundaries are supposed to follow readily determinable somethings on the ground, if you will, whether it's a property line that someone can identify, like a surveyor could say, well, here's this corner, here's that corner, here's the line, or it could be a creek or a road or a railroad or an interstate or some kind of physical barrier as well, rather than just being an arch out through the countryside. You know, here's the town limits, they just do this. You see that a lot in extraterritorial jurisdiction, the arches. So I want to point out a couple things in Article 2 that are critically important for you. The first one's on page 17 in yellow for a reason. And this is going to be probably a little eye-opener for our returning member, Mr. Jones, but I had said at an earlier meeting that, that there are some things in the statute that raise a few eyebrows in this new legislation that passed in 19 and became effective in 21. And one of them has to do with manufactured housing. And so we have to we have to position ourselves. So what you'll see in this Article 17 is a prohibition on manufactured home parks, but for, and then it lists what that criteria is, okay? That's a tested, invented in 1988, first adopted in North Carolina in 1988, written by me, tested in the courts and survived, approach to saying, okay, they are prohibited as a general use, except when they are within a certain overlay district, et cetera, et cetera. If there's one out there that exists, it sets in place some path forward for them, but they can't just sit on their hands and do nothing. You might not have one, but you might have something that is triggered by it, because a mobile home park might be nothing more than 2 units on a single parcel. That still constitutes a park. Don't just think of a 100-unit park, okay? Now, so I want you to see that, and that's a way to set ourselves in position for this piece that I'm about to share with you. This is the statute. This is the new planning statutes. I'm reading from 160D, as in David, 160D as in David, dash 910A. This is the very first part under manufactured homes in the state statute. The General Assembly finds that manufactured housing offers affordable housing opportunities for low and moderate income residents of this state who could not otherwise afford to own their own home. The General Assembly further finds that some local governments have adopted zoning regulations that severely restrict the placement of manufactured homes. It is the intent of the General Assembly in enacting this section that local governments re-examine their land use practices to assure compliance with applicable statutes and case law, and consider allocating more residential land areas for manufactured homes based upon local housing needs. Now, I have never read a threat in state law until that one. And what that says to me is that jurisdictions need to do something, because if you don't do something, chances are in a few years, they're going to pop I like to call them pack of tube socks on you type of solution, where tube socks don't fit anybody well. A one-size-fits-all solution. And it's probably going to apply to jurisdictions that don't pass a certain litmus test. So we want you to pass that litmus test. So we've got 3 angles for that, and this is one of them, to say, we're going to prohibit this, but we're going to give it a gateway if you do have it. The second one is going to appear in the district stuff, where you've at least got an overlay district that could be considered. You don't have to approve it, but it's in there. Now, your first reaction is, let's leave that out of our ordinance. That's exactly what's going to trigger the tube sock solution for you. That's why we need something in there that the legislative body, that's the village council, can consider if an application comes forward, because they can always say no without justification. If you rely on the administrative process, you can't be subjective. Only the legislative process can be subjective. Planning boards can't be, Board of Adjustments can't be, staff can't be. Governing boards, not in approving a site plan, because that's an administrative role, but only in making an amendment. What's an amendment? A rezoning is a map amendment. That's an amendment to your ordinance. That's a legislative process. That's lawmaking. A rezoning is changing the law. That's legislative. That's the only place left where local governments can just say no, period. No explanation required. And it's 100% unchallengeable as long as you did the proper notices and everything else.
Can I
So
ask
that's,
a quick question about that?
okay?
So I'm all for affordable housing, but the statute said that it's based on the community's need. There was a caveat in there near the
Yeah,
end
about need.
About need. And I would say that this is not an area that has that need, like Marvin's not an area that has that need. There are budding communities that
I
might.
completely understand that, but I'm talking about what the state statute says, and how do we defend against that? If you leave the tool out of the toolbox and you need the tool, you're helpless.
So
Just
then-
don't use the tool
So then my
if you don't
second
want to.
question is, we don't have an overlay district currently, because we only have a couple of mobile homes, just a handful, like, in the entire village. And I know there's that replacement, like, there's that replacement rule, like, if it is condemned or needs to be.
We've got that in Article 22.
Right,
That was
right.
one of the 3 tools in the toolbox.
Right, right.
So the replacements can be done, provided you meet all these standards for the new installation, but it can be done, because what was happening is people were ignoring them, hoping they would eventually go away, and a 50-year-old one in 50 more years will just be 100 years old and still sitting there. So it's better to let them replace it and to have a policy. So I've written something that I believe will survive the test of, is it a park that exists? Is it an individual unit on individual lot that exists? Or is it a proposal for something new? So I use a manufactured home overlay to address new installations where there were none. And that is, by it being an overlay district, that is a rezoning. That is a legislative decision. That is something you can just say no to. If you don't have that tool in the toolbox, and they send you they order you a pack of tube sock solution, then
I see where
you're
I
gonna
see
be,
where
you're gonna
at
be
now.
saying, gosh, that Mr. Flo, he was onto something.
Well, we don't have any current parks, we just have individual mobile homes on single lots.
Do you have 2 on one lot?
Correct.
We have
Anywhere.
2 on one lot.
I don't think so, but that's what he's saying, is that even though it's not a quote-unquote approved mobile home park, or was, or is, if there is 2 on an existing parcel of land, then that could be defined as a mobile home park.
No, I understand that, but we don't have that currently, right?
I'm not 100% sure. Are you saying like an existing condition in Marvin? Because I don't think we do, but I'm not 100% sure. I'd
I
have
know
to
we
go.
have mobile homes in Marvin.
Correct.
I just I was not aware we had a mobile home park, whether it consists of 2 on one lot or more than that.
Like I said, I would have to go look at, the maps, but I'm not 100% sure. I don't think we do. Like I said, the only ones that I know of are there ones right there off of, the only one that I know of is the one off of Newtown Road right here.
Okay.
It's not gonna hurt you to have language in there to protect you from something, even if you don't have it.
Yeah.
The point is, it shows that you've got policies that address it. You don't just have this one word that says no.
Yeah, that makes
Okay.
sense.
That's what I'm suggesting, Madam Chair, because that terrified me, and that's the item A, under the whole section in the statutes on manufactured homes. That's the very first thing that they say.
And to add to, it's good to have this in there, because as we do look to, annex property, have properties come annexed in, who's to say that there's not a property in Union County that has this? And so if they come to the annexation, we could just rezone them the normal residential, but then it would be on that property owner to come and then apply for the rezoning for the overlay for it to
Well, what they could do is they can continue,
Yes.
but they can't expand or anything without that overlay, okay? That is what puts that legislative, remember this whole process, this is something that Mr. Jones hasn't heard any conversation about in the past, but the way the statute changed, it really took away subjective decision-making, especially from planning boards, and also from staff. We can only go by what's written, okay? Or either if there's something that fits in the cracks, we have to come up with some kind of logical linkage for it and then apply that consistently. We can't just make it up. You can't just make up an answer. So I've tried to make this to where they're not gonna look at you. What have you got in your ordinance? Well, we've got provisions, we've got an overlay district, we've got all that. We've got the tools in the toolbox, so it would probably not be applicable to you. Because they're not gonna punish towns that are doing what they're asking people to do. They're gonna punish the towns that are bucking the legislature. And there's a handful out there that cause 99% of our legislative headaches. One rhymes with Harry. One rhymes with Helmont. I could continue on. There's a hill in one of them that have been the thorn in the side of our legislature for a long time, and it causes the legislature to react. And I'm not a fan of poking the bear, especially when the bear's already on a rampage. And our legislature's been on an anti-municipal rampage since 2013. So, okay, I don't know if I'm sure of it now. Right. If they're not in the area. Accessory dwelling or accessory structure? Right. Right. Okay. Right. Right. What I was getting at, though, in that second question was the accessory structure is not an accessory dwelling, it's a non-residential accessory structure, meaning you're storing your lawnmower in it, you don't have people living in it. But it's also part of the security of the lawnmower. Yeah, okay. And that proves my point. Okay. I take everything I said back that conflicted with your point. There's different zones too, you have to consider that, zone A's and X's. Well, there are several different zones, but your flood hazard area, okay, and the different zones calculate that a little differently. Your flood hazard area is typically your 1%. That's exactly, that's why I brought up the special flood hazard area. Right. The next one that I want to point to you is, that I want you to think about is still in Article 2 on page 19, where I've highlighted in yellow provisions for potable water supply and wastewater disposal infrastructure. This is wells and septic tanks language. And there are some crazy practices out there of putting shared septic fields on common area and all the houses in the subdivision pumping to the same area and all that kind of stuff. And one of the things that I wrote into ordinances a number of years ago was that that could not cross other private property, that it had to, if I was pumping from my lot over to the center of the neighborhood, the joint septic field, that I couldn't cross your lot. And so I was writing the ordinance to say it had to go out and then maybe follow the street right away or something like that. So when you bought the house next door to me and you went out to plant the dogwood tree or whatever, you didn't discover my little force main when it kicked on the hard way. And somebody in Unionville, which is not far from here, took offense to that language. And the legislature passed updated legislation that slapped me on the hand and said, no, no, no. And so what I do is, since I can't prohibit that anymore, because I was prohibiting them from using off-site unless they owned it, okay? Or unless the common area owned it. You couldn't just send it to some vacant lot where somebody volunteered it. You also needed to show it on the plat with an easement for that line. Common sense things, which you can still do. So that's the revised language here on page 19 for those situations that fits within the Unionville test case, we'll call it. I had to go back and fix Unionville's ordinance within about 6 months. Yeah, somebody didn't like the fact that we wanted to do that in a sensible way that set future homeowners up for success. So I wanted to call that to your attention. And last but not least in here, I didn't yellow it, but I'm having second thoughts about whether I should have yellowed it for you or not, and it's on page 20. And it's mostly because I got tortured on the phone for about an hour today by a coastal community that, has a lot of 14-bedroom homes, and this week some group will be in one of them, and next week another group will be in there, and so they're essentially hotels in the summer. And different towns have different feelings about short-term rentals. So I wanted you to see a pretty robust one that does not violate the Wilmington case. Wilmington went off the rails and got their hands slapped big time by raffling the privilege. So if all of us set up and bought us a Airbnb unit, renovated the house or something like that, and there's 10 of us in the room, and every year the city council said, okay, we're going to issue 5 certificates for this year, and we're going to raffle, but all of us put money into renovating the house, but only 5 of us get to rent them out. The other 5 have to wait, and hopefully next year we get drawn. Or maybe the next year we get drawn. The courts pop them, well, really, they've slapped them upside the head on that one. This does not violate that, just so that you know. That's a pretty well talked about case. But this does set in place some pretty robust standards for that if that becomes an issue here. I doubt seriously y'all have a big issue with that here, but I don't know. Do y'all have a short-term rental issue? Houses being rented out, Airbnb, to the point where you got parties and cars parked all over the yard and all that kind of stuff going on?
No, that's where, with Marvin being majority residential and within subdivisions, the HOAs kind of have regulated themselves.
So you may not need this at all, is my point then. But I wanted you to see that, think about that. If you're not a tourist destination, really, you're definitely a bedroom community. Does anybody work here in town? Yeah, that's my point. Only Hunter and Austin work here in town, right? But they don't live here. So anyway, that's my point. So we can take this out if you'd like. I want you to think about it and just let me know.
It's not on. You know, so when I go up to the mountains, I always pass Tryon, the equestrian thing there. So like, what if something were to move in, you know, into South Carolina, like just across the border? We're one of the closest communities. Like, we never know what the future holds. And we've been kind of, you know, I know that up in the mountains, you know, with the new types of rental units that you can have that aren't standard homes, their ordinances are not keeping up, and so things are just crumbling up there. So, like, I would rather have something in with language
And not need
in
it.
there and not need it
Right.
than like be faced with it and we're not prepared and we don't have to like then go back and, you know.
Sure, and there's pretty.
You always have the possibility of ADUs being built on these large lots and
Well,
then being rented.
ADUs are going to be an entirely different topic. And they can be used for these if you're not careful, right? And that's what you need to think about. Now, what he means by ADUs, that's accessory dwelling units. That's like following the recession in 08, 9, 10, 26% of college graduates returned home. Excuse me, it was more than that. Of 26-year-old college graduates had returned home. I don't remember the statistics now. It's a little old on me, but it was a high
That just
number.
sounds frightening, so just keep
And,
going.
and so ADUs became somewhat popular, where you had a separate entrance, and they had their own kitchen and whatever. And in my
Same
neighborhood,
during
there are
COVID.
some, you know, so. And the legislature right now is also toying with the fact that you can't say no on that. And they'd kind of backdoored that in Senate Bill 25 back in 2013. This is really bad to remember these things, where they basically said we can't control the use of rooms. And so what does that really mean? Can I have 2 kitchens in my house? Yes.
Did you see that there was an area that was doing something different with ADUs? I remember you that they were restricting them in some way.
You talking about the legislature or another town?
Not recalling. I mean, we changed our ordinance to allow, basically, the ordinance prior read that accessory dwellings were allowed if they were connected to the home.
You can't do that anymore.
Exactly. So we changed it where it's still allowed. We have standards in place where, you know, I think there's a size maximum, and then characteristic of it, and it's a special use permit. But that was kind of, once again, it was done because ultimately what's happened in Marvin is people have built pool houses or accessory dwellings and quote unquote didn't have a kitchen at first or didn't have certain things to get it permitted, and then they'll come back in after the fact and then do it / just not pull the proper permits. And we don't know until we get a call saying, hey, somebody's living in so-and-so's backyard.
I'm involved in, as an expert witness in a court case in the city of Charlotte right now on that exact topic.
So,
They pull their permits to build a big garage, big home, nice area, Queens area. And they came in, built a monstrosity of a garage with, you know, incredible tile showers and everything upstairs and this gourmet kitchen and, you know, yeah, well, that's the garage, you know, it's just the garage. So point is that's a thing. Now, you'll see in Article 10, I have a good ADU, accessory dwelling unit, standards that apply to any accessory dwelling unit anywhere in town that deal with the attached versus detached and all those aspects of it. So you'll see that when we get to that article. Whether you're converting or whether you build it, you know, whatever. We've got standards for that you'll see, and then you can say you can tell me what you like and don't like about them and everything else, but you'll get to see all of that. Those will be in a section that is specific to uses with additional standards, Article 10. If you look at your reading guide, you'll see Article 10, uses with additional standards and special uses. That's the scary stuff, which also has a lot of additional standards, okay?
Can I ask you a question really quick?
Sure.
When, the last time we saw you, you made me a statement, and I can't remember what it was, but it was like, you can control the use, but you can't control the, like, what someone does with the like, do you remember what we were talking about? Like, it was actually about
Yeah,
ADUs, but,
we can't control behavior, but we can control the use of the property. Was that it? Because, you know, if they.
what
if
you
they
have to report to when you're applying for permits and things like that.
Well, that's right. We also can't control how honest they are or not honest they are. We have to look at that very carefully to see. Sometimes they'll give us clues. Oh, unfinished. Big, nice second floor up above the garage, unfinished space. Oh, that's storage. You know, those kinds of clues usually point to something. That's exactly what happened in that case in Charlotte. It's
But
exactly how it got
for
permitted.
our role, though, we.
For your role, you won't be involved in that,
Sorry.
yeah.
But you made just like this one statement I thought that was really helpful, is that, towns can do X, like we can control X, but we cannot control,
Well, that's true. We can control the use of land and we can control the development standards of land, but we can't always control the behavior that happens, that surrounds that.
You can't access the property without them allowing them to, and if they're doing something they're not supposed to, more time.
Well, there are ways to do that sort of thing too, legitimately, if you need to get in there. But that's right, you can't always tell what's going on, so you have to look at clues. We had one today. Somebody in a little town, one of my employees called me to try to flush this out, wanted a home occupation permit. You know what a home occupation is? It's basically, I'm using this spare bedroom where I sit down and I work remotely from home with my little laptop or computer, and, I might have a printer and I might have a scanner or something, but I don't have machinery and employees coming and going and a big parking lot in the front yard. A home occupation is kind of a benign, my grandfather was an accountant in his latter years working from home, worked out of one room and things like that. Bona fide home occupation. This person was wanting a sign-off for their alcohol, tobacco, and firearm license application as a gun dealer in a home occupation in a neighborhood. And I don't know what they were doing with that, but the point from a land use standpoint was, are you going to have inventory? Are you going to have shipments coming and going there? Because we have standards for, not generating this abnormal traffic, like delivery trucks all the time or something like that. Are you going to have employees coming to your house? Are you going to have customers coming to your house? And I said, we just got to peel this onion back and find out a little bit more about it, because he made the statement, most of my business is at gun shows and most of it's online. And so I told Susan, I said, Susan, you need to find out what the lesser side of most is. Is that selling from the home or not? What are you doing? Are you going to have inventory there, or are you just a broker dancing online? If you're just a broker dancing online, I don't care. But if you're going to have a lot of shipments and you're going to start having this and that, the next thing you know, in the last case I had like this on a home occupation for a gun, turned into, it was gunsmithing in the house. And people were coming and going all day like a regular business, and the neighbors were complaining and everything else. And so we kind of dropped the axe on it and got it brought under control. And so because he was a commissioner on the council, I no longer work there. But at least he's downtown now in a real store. So he paid me back for doing my job, but I did it, which is what counts. So you get into, Madam Chair, you get into these areas where land use and development standards, which are clear-cut and our authority's clear, but we have to dance with behavior all the time. And that, I don't know if that's the topic that we were talking about or if it was something else, but it's not my memory's not
It's okay.
jogging on that.
It's going to come to you at 3 in the morning.
Let me introduce you to Article 15 for just a moment. This is another one of those kind of early sticking our toes in the water into character. You know, the first one was all that general stuff like fences and swimming pools and accessory structures and driveways and short-term rentals and mobile homes and all that stuff. This number 15 is the flip side of that coin. This is your temporary events and structures. This is the hot dog sale at the fire department. This is the selling produce on the side of the road, the
Christmas
tailgate
tree
market, the
sales.
fresh fruit market, the whatever, pumpkins, watermelons, Christmas trees. It'll, if we went back to the 70s, we'd have, dogs playing poker. Anybody remember that one? Does anybody actually know what I'm talking about?
The velvet paintings?
The rug-looking things that were the dogs sitting around playing poker, right, the dogs playing poker, all of that stuff, what's the most popular thing right now that would be kind of temporary? Anybody? Let's see who's on top of the latest trends. You want me to give you one little clue? It happens in a truck. Food trucks. Some towns hate them, some towns love them. I never know till I ask, how well does the town like food trucks? Wonderful, greatest thing since sliced bread, can't stand them, don't want to see them. This is the article right here, and it's only 6 pages long, that is introducing you to. So when you see the numbers in here, please don't shoot me. When you say 60 as a frequency, I can show you drafts of other towns that have adopted, are you ready? 153. Excuse me, 156, which is 3 days, 3 times a week, year-round. I have had towns adopt that heavy. I've even had towns say, don't put a frequency limit. We love them. I've had towns say 5 per year. Okay? There's all kinds of different philosophies out there. But when you read through this, what I want you to see is that we have this where it references, see this note and that note, where they can't do it in the right of way, they can only do it on private property, it has to be in a commercial district, or if you're doing it for your child's wedding, graduation party you're throwing at the neighborhood, then it can't be in the public street, it has to be on your property, so the food truck would pull up into your driveway and give all the attendees of the party their burritos or whatever they're doing. So we've got these standards written around this stuff, so this is gonna bog you down unless you give me some real simple answers like, no, we hate all this stuff. Then it becomes quite easy.
Boy Scouts with Christmas trees, during
Well, another one I thought of, and I haven't had to be involved, my kids are too old, my grandkids haven't gotten there yet, but these game trucks, evidently, they pull up for birthday parties.
Yeah,
I mean, is that something that, I don't know that we try to control it now, but should we, or?
No, because they're supposed to go into your driveway. So like, when my boys were little, we had a game truck and they just pulled into our driveway. So it shouldn't need a permit.
that's fine.
They're only there for like a couple of hours. And
Yeah,
then they leave.
that's fine.
As long as
I
they're
mean,
not
I don't know.
blocking traffic and,
I mean, like I said, I have no experience, I've just seen them going down the road.
Are they accepting money from each of the children, or you're paying them to come and
No,
do
no,
this?
it's like you rent it. Yeah,
You
you
rent it.
rent
See,
the truck.
that's normally not a problem, where the thing that separates it is when there's a lot of transactions.
Yeah, that's a private, like.
Pumpkins out of the tailgate of the
Yeah.
pickup truck, or Christmas trees on the Christmas tree lot, or hot dogs at the fire department, or the church, or something like that. So the food trucks are really transaction-based. They're not, unless you're gonna hire one to come to your party and, you've already prepaid them 10 grand to give everybody a burrito that wants one, or whatever. So that should work.
Hunter, this outdoor bazaars and retail sales with temporary structures, the 2 per calendar year, I mean, if we're gonna do, if we, eventually might wanna do, produce markets and things like that, a lot of times people will sell like, candles they've made from their beeswax and,
That's
artisan
over on the
jewelry
other
and art.
page. That's on page 2 right there. That's where you're gonna see Christmas trees, pumpkins, other seasonal material sales events by commercial vendors and those by
I'm talking about
nonprofits.
page 3, outdoor bazaars and retail sales.
Okay,
So sometimes that goes along with, like markets and fresh food, like,
I was about to
farmers
say,
markets and stuff. Farmers markets, there are sometimes artisan craft dealers there, so I'm just saying, like, 2 per calendar year sounds
Well,
a little extremely, yeah, a little low.
correct.
no, all
me.
you gotta do is tell me what the number is. These are all just
Well,
filler numbers.
I guess my question / building off of hers, making sure for clarification, is that's more if it's single, like if it's a single vendor setting up, if it's a vendor being a part of a farmer's market or event as such, I think it would fall under that umbrella and then that timeline of how, because then it's falling under how it's the event. So if we have a farmer's market that's selling produce, food, and you have the vendors that sell, candles and other things, it's falling under the umbrella of the farmer's market, not that. That would be if it's an individual person setting up shop in like a parking lot of like Marvin Gardens.
Okay, I get you.
Is that,
Yeah,
Yeah.
I kind of see your point,
Yep.
but,
Yeah, this involves with temporary structures, like they're setting up some kind of, I've got one in one town where they're gonna have these little, they're almost like little storage buildings that are kind of decorative and everything, and they wanna set them up for a little while.
they use containers on wheels, on chassis.
Containers,
and then they
all
bring them,
kinds of
yeah,
stuff,
it's like
yeah.
store- it's like
All we
bottles.
need to know is where the numbers need to be, and,
Example of the other side of the retail sales about temporary structure. What are you thinking about? What's an example?
kids selling lemonade? It could be, but yeah,
Well, would that be something
Would that-
in
Garage sales?
well,
Garage
let's
sales
say
is already
Marvin
identified.
Gardens, and you have a clothing store, and they want to put a rack out, would something like that be?
Because that's what I would have thought that was,
that's
not
what's
lemonade
down one
stands.
more notch, is the outdoor sidewalk and retail sales without temporary
Well,
structures.
that's what we're talking about.
That's what I was,
I mean, I think that's, well, I mean, I would imagine that their
yeah.
Marvin Gardens will have,
At some point.
do they have, does that district have,
it's the same thing if Publix puts
Come to
out
us with a-
flowers and certain things in front of the entrance.
I think, I almost feel like I would never would have, seeing outdoor sidewalk and retail sales without temporary structures, I don't think I ever would have gone Girl Scout cookies and lemonade stands. I think I would have done more like retailers, like going out into
Yeah.
the street.
A rack of
A rack of
clothing or
clothing,
something like
yeah.
that. Yeah,
Or
that's
like,
what that's about.
Yeah.
And how would this,
So how do you capture the Girl Scouts and the Boy Scouts with their popcorn and,
Put it out on Marvin Loop or something, start selling to people, walking on Marvin Loop.
And that's really what captures this. If you're selling the cookies at the front door to the Home Depot or something like that, it says all products and advertising shall be limited to the area directly in front of the sponsoring vendor, like it's sitting right there. It's not something you see out by the highway or at the main entrance or what have you. So,
I mean, so is there a way just to maybe clarify, like, where would the Girl Scouts and, like, where would Girl Scout cookies and the Boy Scouts popcorn and
this
like,
outdoor
lemonade?
sidewalk and
Yeah.
retail without
and
temporary.
it's not
the
required
one
by
you're looking
permit,
at.
so if somebody just does it,
No permit required. If they're on a public sidewalk, they need to maintain a clear path, like if they're, so they're not obstructing the sidewalk. If they're on a premise, you know, they're gonna, like a sponsoring vendor like Home Depot, they're out there by the entrance to Home Depot, that's all fine and good.
But we're not, so,
Most towns don't want to restrict that too heavily.
But it's,
Yeah.
it's also, it's the tool in the toolbox, like, if they're setting up in Firethorn, whatever, and like, unless I get a call saying it's an issue, it's never gonna be an issue, and all that is that if it is an issue, we have parameters in place on, okay, what is the issue? Okay, they're blocking the travel lane, okay, they're not supposed to be, then we can address it.
That's exactly right.
so,
That's exactly how it
so
goes.
what about, I mean, what about panhandlers?
It's addressing a
Itinerant
different
merchants and panhandlers and things of that nature is not really a land use. That's more of one of those behavioral issues. That's typically dealt with through your police department type of scenario, because it's not really a store sitting there sponsoring this event or conducting this event. That's what this is about. This is about what are the rules for people doing things like that. If you're panhandling at the intersection out here, that's a police department issue, not a zoning issue.
And we have something in our code of ordinances already for panhandling. I can't recall what it is off the top of my head. I've seen some municipalities require where you have to get a panhandling permit.
If we put it in this ordinance, just to give you a little linkage test here, Madam Chair, if we do put it in this ordinance, then when we cite them for a violation, we have to cite the property owner, because the property owner is responsible for the land use.
Yes, I see.
So
Yeah.
if it's more of that panhandling or itinerant merchants, you know, we've had situations where, I know 15 years ago, I don't know why, but apparently somebody somewhere made way too many recliners. So there were tractor trailers parked in, you know, businesses on Sunday's parking lot when their business was closed, selling recliners for $79 or something like that. And the local furniture store would be all upset, you know. And so those itinerant merchant ordinances are typically not contained in here. They're contained under police department type of setting.
So,
And panhandling's kind of in that group as well.
so a temporary structure would not be considered a folding table?
No. No.
Okay, so, just devil's advocate here. So if I am an excellent knitter, I'm not, so don't ask me for booties, because I don't
Is she
knit.
giving herself away?
But I know, there was this woman that used to do a lot of knitting in Valentine, and she would set up near the Harris Teeter, and she would accost everyone that walked by, asking you to buy her knitwear, you know.
Was she just using like a folding table, or did she have a little shelter
She
thing?
had a little, just a little cart table thing that she had her stuff on, but like, it felt panhandling, you know what I mean? Like,
Right.
so in this scenario, she could do that
She could do
wherever
that,
she wanted, as long as she wasn't,
assuming she's got the property owner's permission.
That's what I was about to say. It also comes back to the property owner, that if it's creating an issue, like if somebody were to do that out front in Publix, like Publix is going to either say yes and allow them to do it, or if they don't and they're just doing it, then most likely Publix is going to say something.
Yeah.
so just, my point is that if the lemonade salespeople, you know, were to look at this, I might not think of, I need to go ask.
They can't block the sidewalk. They can.
No, I understand that, but I mean, I can see like what I have to do, but like Marvin says I can do this, and I don't need a permit for it, but there's nowhere here that says I have to ask permission from the property owner. Do you know what I mean? Like, it's
We can add
type of-
that.
It's that type of thing that we want people to be able to pick this up and know exactly what they need to do. If you want to have a lemonade stand, you need to ask for permission from somebody. You don't have to ask for permission from Marvin, but you gotta get permission from, you know, the property owner where you wanna set up. Now, what if that's on
And
public
we
property?
can add that, but I'm just thinking realistically here is that if they don't ask permission from the property owner,
It's trespass.
then yeah, it's like, it's gonna regulate, like, once again, it's, you're kind of putting it in here, and if they don't ask permission from the property owner, then it's gonna be an issue one way or another, as in, if it's an issue with the property owner, they find out or they didn't want it, then the property owner can address that on their behalf, and/or then it could be, once again, if it's an issue on the property owner because they're violating, once again, if they're blocking the sidewalk or doing something, then we still have that part of the ordinance to fall back on. I mean, we can put it in here, but as in like having a provision where it says, must have property owner's approval. Well, at the end of the day, if we're not requiring to get them a permit, how am I gonna know if they have property owner's approval?
What's the difference between outdoor sidewalk and retail? Definitely there's and yard sales, you get, yard sales restricted, but you don't have that.
Yard sales, yard sale is a defined event of selling, like you're advertising a yard sale this Saturday on your property, so you restrict that the amount of times per year.
But is that, hold on, where'd it go?
Some people are in the yard sale business. You know, you ride by and you see them every weekend.
And, well, that's where the art of administration comes in, because temporary versus somebody that's got this thing going on, we have to make a determination. People in our role have to make that determination. Does this qualify as temporary, and how does it fit? Or has this become permanent? Is it showing signs of becoming a fixture? Okay, like I see food trucks sometimes that are supposed to leave and come back, but you can tell they haven't moved in 6 years. And what have you. So that's not a temporary structure anymore.
Why wouldn't you have day limitations on outdoor sidewalk and retail sales without temporary structure? Like you do on yard sales? Why wouldn't you have?
We
you
can
know,
do it.
Some.
This is a draft for you to tell me what you want to change.
Absolutely, yes.
Okay? If you want to tighten screws down on certain things, not a problem there. This is a template from which to prompt your thoughts. And so don't shoot me because it says unlimited, because I'm not recommending that something be unlimited or 2 per calendar year. I should have yellowed all of those so that you would know that this is for you to tell me what your tolerance level is. Is it something to control? Is it something you don't want to control? Is it something you want more strings on? Is it something you want less strings on? That's easy.
What about, like, for food trucks, though, like, what, like, what if it's on, there's a development being developed, and you've got a lot of construction workers, and, you've got these little, they're like mini food trucks that come and serve, they bring breakfast and lunch and things like that.
Yeah.
Right, so I mean, like, would they be required, if it's in a development, which is technically private property, I guess, because it's being developed by the developer, they wouldn't need a permit because it's on their property.
Right,
That's correct, right?
that's
Okay.
right.
Because like I said, the intent of this and where the permit comes into play and the one per, or the, as it's written, like when they're allowed there for 1 day and up to 30 per calendar day is basically if it's public sales. Because to his point, then it's like you don't want it then to be become a permanent thing.
I don't know, I'm a little,
There's a long list of conditions that go with this at the back that, once you look at it and read through it, you'll see, and some you might want to change. I can't read your minds,
yeah,
so
I
I need
think
your
that
feedback.
outdoor sidewalk and retail sales section that's unlimited and no need for a permit makes me a little bit nervous, because,
That's okay. All you got to do is say it, and, we're going to be discussing this at your next meeting.
okay.
This is just the introduction. Don't shoot the messenger. I'm just giving you something that it looks like.
Don't worry.
Yeah. Think through it, read the notes, read all the conditions, because some of the rapid-fire questions may be answered in there as well. And some you may not like the answers to, you might want to change those answers, and that's okay. Do you have a police department, or do you contract with sheriff's department?
We contract with the sheriff's department. They are employees of the village, though.
Okay.
So that we have 2 deputies that are technically employees of the
Okay,
village.
so
And
my
when-
reference in here on page 5 to the Village of Marvin Police Department, that's why that's yellow, because I want to make sure what your arrangement was there.
But in short, we're always open to as we grow. That has been something that has been discussed of us establishing our own official department. So my question would be, could we leave it like that / just add
See on page 4, that's what I'm gonna do.
Yes, I was about to say, as long as we, I was gonna say, or any other, governing or applicable law enforcement agency,
Right,
yeah.
And/or Union County Sheriff's Office or something like that. Because if you're contracting with them, then that would cover that. A lot of small, generally paper towns will have a contract with the local sheriff's department.
What's the difference between D and E? Or in Market, Tailgate, Fresh Foods? Like number
Between
6?
D and E,
Yeah, so in number 6, the Market, Tailgate, Fresh Foods, blah, blah, blah.
on D, as in
6D
David,
says, for locations on private property, a no-cost permit is required along with written proof, but then it's an E, it says, EI, it says, or E1, a property owner may sponsor a food truck to cater a private event on private property.
the big difference is whether they're basically dealing with the general public, transactional, versus whether they're there to essentially provide services to a limited group, like that reception or party, graduation party or something like that.
So is there a way to add something about, if serving the public, or if public transactions, or, I don't necessarily know if that's clear. Did
So you're
anybody?
saying if I'm gonna have it at the HOA, and it's gonna be transactional, then they should have to have a permit?
That's what's going on in my neighborhood right now. I don't really do it. I'm not a food truck kind of guy, but we have those like 2 or 3 times a week. Different food trucks from different places will be at our clubhouse, like for 2 hours on a Wednesday evening or something like that. So on D, maybe clarify the intent there of who we're targeting there, that we're talking about the general public.
Yeah, just that it's,
Sometimes I will try not to over-tighten something.
yeah.
If it leaves a gap between this thing and this thing. So
It's
sometimes
just, those two things right now seem like the same thing, though.
well, they generally are close, but one of them is really dealing with events that are sponsored by something. And so I can clarify that. Otherwise, if a food truck pulls up to a location and just starts doing their thing because they see an opportunity, versus a food truck that's been invited by an HOA or a family to host a, teenage person's party or whatever the case may be, So we try to leave it broad enough to where the umbrella will sort of catch the topic. And then the particulars of these situations is where we then have to zero in. And it doesn't happen as fast as I'm trying to answer them in here with all the different questions about what
See,
about
what
this,
you
what
just
about
said
that.
makes sense, but when I read it, that's not what I read. Like, it didn't come through, so.
The Art of Bill Writing by a former bill writer to Governor Smith of New York State is the one that I learned that from posthumously. He's been dead a long time. But I subscribe to that approach, to not over-tighten, but to be careful not to leave gaps that I can't fill. In other words, I'm looking at a situation, I've got a location, this is what's happening, these are the parameters. Now I can study this for a few minutes and I can make my determination. If I tighten it up, let me just use an example, and I haven't thought this all the way through, but I'm just going to use that example that you put on the table, Madam Chair. If I say something about general public, and then in the other one, it's talking about private property and homeowners associations, is there a gap in there? Is there a gap? Is there a scenario we can think of where, well, it wasn't the general public, but no, it wasn't an HOA or a private event on private property? There you go. Now, we've got provisions in here for what I call town-sponsored events. That might be something like the town makes the park available based on certain criteria for certain events.
Do we have that in our, because we do rent out the park and facilities. Do we have that? And I'm just curious, do we, for example, if somebody were to rent out the park and the barn specifically, or, I mean, mainly the park, for, let's say, a wedding,
Okay.
Um,
We don't typically like weddings, but go ahead.
do we allow for food trucks or any type of catering? Do we have any type of, in our policy?
I'm not aware of any restriction.
And I'm just, that's, because we do rent out the barn.
Well, I want everybody to think these through. Remember, I said this is a short one, but it's got, it opens some big cans of worms. So I really want y'all to think about these and see what your appetite is, and then we can discuss that at your next meeting, if that's okay, so that you can digest it a little bit and think through examples. And this will also heighten your awareness. Next time you're driving down, you know, Providence Road or something like that, and you see something, you'll ask yourself, how would that fit into our scenario here in Marvin if they were to do that?
But
have
to,
a-
I was just to add real quick, to build off of that, like, we don't have to maybe get so specific, like that example I was just using, maybe get so specific within the ordinance, because that's something that we can do internally in our policy for our rental policy for the barn or something along those lines, like where it has to be, I mean, obviously it's not for the general public, even though it's quote unquote on public property, it's being used for an event rented out by a private entity or private person. And so
Covered under like a.
it's covered under that
Yeah.
policy, and we don't necessarily have to get so wordy or crazy in the ordinance, because it would then then I would then consider that, one, they're getting approval from the village anyway to rent the facility, and that's a part of it. But two, then you don't have to worry about it from the ordinance standpoint, because one, it would then comply, because I would just then consider that as a private event on private property to an extent. Like, that's the way I would interpret
This
it.
process of writing a new ordinance opens a lot of cans of worms, because it makes you really start thinking through all these things that you'll find fears, you'll find concerns, you'll find wishes, things I want, things I like, things I think we should be good with. But it makes you sort of think those through, because who doesn't like Girl Scout cookies or lemonade? But when does it potentially become an issue? I didn't bring any with me. The vice chair's perked right up on the cookies and lemonade.
Because we remember the story about your wife's cookies.
I need to talk to
Oh, man,
her,
I
don't
didn't.
I? I need to talk to her. She's on her way, well, Thursday, she's headed for Italy and Greece,
Oh, sounds awful.
and so I'm going to Colorado.
I've got one more thing that I don't see here is, and because I do this, part of this for a living, but, is, collections.
Like, fire department with a boot in the middle of the road?
Or, you know, like, because I run a book bank, so people do book drives for me so like Union County will actually do a book drive, like a county-wide book drive for my organization, and they'll put bins in different places, but I know there are some nonprofits that put those donate books and clothes, donate clothes and shoes, and they are very sneaky. They will drop them in kind of no man's land, or like on the edge of construction sites. I know you've seen them, those big bins.
I
that
have.
just are like in,
There's one down in Puritan by Harris Teeter.
and they don't get permission, they just drop them until somebody complains, and then they go and pick them up. But there's one, actually, there used to be one, and I know who they are. There used to be one on Marvin Waxaw, that blue bin. Anyway,
I like that one. I like
But I
that.
mean,
I'm
you know, like-
gonna do something with that on the collection bins, donation bins, whatever you wanna call them. You're gonna get a nice, story at a future meeting. Looks like next month, or when Article 17 comes out, about a Supreme Court case at the federal level that changed policy nationwide in a humongous way. Collection bin. A collection bin. Went to the US Supreme Court and affected every zoning ordinance in the country. Not over the bend, but the bend did it.
About it next week, but I don't know if you guys noticed, the signage is getting crazy.
What'd you say, signage?
Like
Yep, that's what we're gonna be
advertisements.
going into, yeah.
I don't know if you've seen it, every landscape lighting company is sticking their sign in the ground, all down Waxhaw Marvin.
Well, I'll mention, our current ordinance prohibits those. The issue is, because there are areas where I know where you're talking about specifically, they're not in Marvin. So I can't go, like, no, like, for example, that corner of Stacy Howie Henry Nesbitt in Marvin is not in the village. That guy sits out there with pumpkin.
Waxaw Unincorporated.
Yeah, which is unincorporated Union County, but certain of these intersections, and for example, there by the school, that's not in Marvin. So it's like, if the ones, trust me, I typically hear about if they're in Marvin. And if they're in Marvin, I typically go out and pull them up, call them, say, hey, it's prohibited, come pick up your sign, we're trashing it. Where? It's not Marvin.
So we can control development standards that abut, like on in areas that abut Marvin, but we can't control like sign requirements and things like that? You know what I'm talking about?
What do you mean we can create,
You know,
control
like,
development
the
standard?
boundaries, the boundary lines, like we can affect neighborhoods and things that are,
We can't.
well, why, I thought that we,
Are you thinking
Yeah,
extraterritorial
you think-
jurisdiction?
If they're not in Marvin, our regulations don't apply.
no, ETJ, I think, maybe I was thinking of the E ETJ.
Now, the county's land use plan, one of their goal, basically, in short, like, if there's a rezoning in a area, or rezoning for development proposal, whatever, in an area that is like abutting or kind of in near a municipality, their land use plan basically says to defer to the municipality for that, as in they're pushing for those properties potentially to be annexed, and then if obviously what they're trying to do does not meet our zoning or whatever, then it can go back to the county, but we can still, like, that's exactly what happened with that same property I was just referencing. He wanted to do a boat storage. So then the village basically did a resolution opposing it, and it became part of the recommendation for the county when considering it, and it didn't get approved. But yeah, if it's a sign or something, and it's basically like, what our ordinance says is like, if it's on private property, like as in it's on somebody's property, it's kind of a gray area. I'll typically maybe ask the property owners, like, hey, did you permit this? Because when pools are being built, for example, like Anthony, they'll put it on the property while it's being constructed. And I don't really get really upset about that, but when they put it in the right of way, I mean, because I've had some where they've been out here at the intersection of Newtown and Marvin. I went up there, I had the deputy one time drive me up there because it's a dangerous intersection. I've gotten out, pulled up 5 signs, put them in the back of the car, came back here, and heck, they might even still be sitting out there, but like sitting out by the trash cans over here. But no, those are a different category. It's basically any type of off-premise advertising.
You started this. You spoiled my stuff for next month, and now here you go. So I'm just gonna go ahead and I'm gonna rip the wrapping paper off of it and tell you.
What was the case name, do you remember?
Yeah, it's, Reed v.,
It was the Ninth Court that did it, I've got it right here. It was U.S. again versus Crest Hill, Illinois.
no, that's not the one I'm thinking of. The one I'm thinking about is Gilbert v. Reed. It was around 2015 or so, but let me tell you what it yielded. And I'm kind of jumping ahead now into next month's Article 17 introduction, but it's going to specifically address what Hunter's talking about right here. It's going to help you deal with that, and it's going to help him deal with that. I don't know what what type of issues you're having beyond what I just heard you say, but the language I have in here fixes what you're talking about. And it has to do with, in signage, the notion of content neutrality. Content neutrality, that is the message contained in a sign. And the case stemmed from a collection bin that had a sign on the side, something about the collections, and somebody complained about it. And they complained not about the collection bin, but they complained saying that it was an illegal sign that they couldn't do on their business. In other words, the sign on the bin said Salvation Army or whatever it said, and then here's the business, and its sign rules were something different. And so the city sends the collection bin people a notice saying you can't have this sign out here. This is soliciting donations and everything else, and this is, doesn't fit our ordinance. Long story short, after all the enforcement and the lower court cases, the appeals and everything else, the U.S. Supreme Court basically said that officials and ordinances cannot use content to classify or regulate signage. So let me give you an example, a real world example. If you went back a few years ago and picked up a typical zoning ordinance, under your temporary signage, it would list out several types of signs. One might be a yard sale sign, and it might have the standards for a yard sale sign that would say something like no larger than 1 or 2 square feet, can't be up more than 7 days before the event, has to be taken down within 3 days of the event, or 10 days, or whatever, some little number of days and little size. Then you would go over to the real estate signs that had a certain size limit maybe that you put in your front yard. Back in the old days, before everybody sold their house online, you'd stick these metal signs out in front of your house. Some of you may have even seen them that said house for sale. And they would usually not have a duration because it might take 6 months to sell a house or whatever. So other categories can't come into the mix, but let's use those two for this example. Also contained in your draft ordinance up in Article 1, also contained in your current ordinance, and I don't remember exactly where, are two provisions that are very broad. One of them is called the severability clause. The severability clause basically reads that any provision of this ordinance that is deemed unconstitutional or invalid by a court of competent jurisdiction shall be treated as being severed from this ordinance and will not invalidate the remainder of the ordinance. So one little caption that gets thrown out can't take your whole ordinance and kick it to the curb. That's the severability clause. A second clause is called the conflict provisions or conflict clause. The conflict clause says that if two provisions of this ordinance are in conflict with each other, then the more stringent shall apply. Okay? So what happened when that Supreme Court case hit? To all those ordinances that said that real estate signs could be 4 square feet and had no time limit, and yard sale signs could be this or that. Now, the severability clause would go in and it would basically strip those individual categories of signs from the ordinance. But what does that leave us? Because there's a sign on the pole that says yard sale. And there's one in front of that house that says house for sale. How long now? Because now the conflict clause comes together. Now we have not 2 separate categories of signs, but only one. We'll call them temporary signs. How long can a yard sale sign stay up? 7 or 10 days. How long can the house for sale sign stay up? 7 or 10 days. How big can that be? 1 or 2 square feet? Now, how big can that one be? Only 1 or 2 square feet, because you can't read the sign to determine its classification of application. Now, I'm convinced that we're gonna have a follow-up case at some time, and I've been begging for it to happen, that says, wait a minute, let's add a little clarity over public safety, things like that. So in my ordinances, I take that gamble and I say things like public safety, warning, high voltage, stop, okay, speed limit, or exempt. I exempt those in my ordinance, knowing that I feel like if another case were to come, that those were not the intent of the original regulatory side of signs, which was to control advertising, basically, not public information. So that Reed v. Gilbert is the name of the case. I believe it was around 2013 or so as well, maybe 15, something like that. But that's the case that streamlined our temporary sign regulation. So now our temporary sign stuff went from being about 4 pages to about 1 or 2.
What about, and I'm sorry if this is a rabbit hole that we can go down another time, but you will frequently see people on corners with political or religious signs stating their opinion with visuals. And unfortunately, when we were in LA, I was at the beach, I had 2 young kids, and there were very graphic, very large, like 5-foot pictures of things that I didn't want them to see because they were too little, and I had no control. I literally had to tell them to look down at the ground, but I didn't have any control over it. And there were people walking around with all these crazy signs. So,
a temporary sign is a temporary sign is a temporary sign now under our standards, whether it's a banner, whether it's one of these sails that's sitting out, looks like a feather or a sail out sitting out in front of the convenience store. It doesn't matter. We will have standards in our ordinance that deal with those. So what can the duration be and what can happen there? Now, any kind of pornographic, obscene, any of those things actually fall under criminal, not land use law. So that is a little bit of a different subject, but generally speaking, temporary signs are temporary signs, and the way you'll see them drafted is, do you want to have the ability to use feathers or banners for certain special events or not? Otherwise, if it's one that you would stick in the ground, like a for sale sign for your house, or a yard sale sign, or a free puppy sign, or a you pick it out sign, a temporary sign, they can do that. Now, while we're on this topic for just a second, because this is a huge rabbit hole, signage is the most creative area out there that comes into this zoning world. It's far more creative than architecture and everything else. It's nutso out there. Hunter brought up an issue about signs in right-of-ways and things of that nature. Our rules and our ordinance will talk about these temporary signs when they, and if they're on private property, here's the standard. They will all be, in the draft I'm going to share with you, they will all those temporary signs, so vote for me, I'll set you free, all that crap is going to be prohibited in the public right-of-way. So if you want that, vote for me and all that, put it in your yard. It can be, you can use the same sign, just change it from yard sale to free puppies to vote. We can't touch that with a 10-foot pole. Gigantic asterisk. General Assembly in Raleigh, the ones that I'm like, never know what's coming next, is in this, well, it's not in 160D, it's actually in a different section, and it's cited in the ordinance, the actual number, I think it's 138 of the statute, but you'll see it when you get your Article 17. The state of North Carolina's state law is in conflict with that Supreme Court case. And so we, at the municipal level, are stuck between a rock and a hard place, and we'll call the feds we'll call them our grandparents, and the state's our parents, because we're a political subdivision of the state. So here's this difference between our grandparents and our parents, and so I put in there the language that says that their political sign, I don't say political, temporary signs are prohibited in the right of way, so none. Don't go out there and stick your puppies under the stop sign at the intersection. Don't do that. That's in the right of way. And I say except for signs in compliance with, exempted in compliance with NCGS 138, whatever it is, that says, the state says, political signs can be in state-maintained right-of-ways for a period of X number of days, provided this, provided that. So I got a call one time, not long after that had gone into effect, where somebody put a political sign in front of this individual that called me's mother's house. And they called us to report it, and I said, there's nothing we can do about that now. It's in the right of way? Yep. There's nothing we can do about that right now. State maintained road, nothing we can do about that right now. Town street, yes, I can go yank it out of the ground. State maintained road, I can't touch it. And they said, well, it's somebody my mother would never support, and it's offensive. I said, I can't help you. You can call their campaign office or whatever you want to do, but they have been given a free pass by the state legislature to put those political signs up.
And
Now,
if they were to remove it, that's private I mean, it's,
Wasn't there like I feel like during the previous election, there was somebody going out pulling up like
oh,
a
yeah,
candidate sign, I won't specify.
pulling
here,
up each other's signs, yeah.
But pulling it up and somebody caught it on camera and everything, and it was, I felt like it happened in this area, somewhere obviously in the Charlotte.
Well, that's
media.
theft.
Yeah.
You know, that's what that is. That's theft. But anyway, so you want to talk about a can of worms that we cannot get a lid back on? Wait till we get to signage, Article 17. It is the most challenging aspect. I hate it. I hate it. I hate it. Everybody's got different feelings about it, and it's so difficult to write around these cases. Permanent signs are not so big a problem because a permanent sign like McDonald's, a set of golden arches or whatever, you know, it is what it is. And we give the same privileges to all the businesses in the same districts or whatever, you know, not a problem there. But temporary signs are a big problem, because you never know what's coming next.
thank you, sir. I appreciate it.
I will see y'all on the 19th.
19th, we'll be here. Most of
Bring
us.
cooler weather with you, please.
I will drag as much Colorado weather back with me as I possibly can.
Just not their smog.
Okay.
Well, that's just Denver, but anyway.
We're going to, my cousin's going with me. He and I are going to Manitou Springs, and then we're going up to Estes Park. Enjoy. Thank you.
Thanks, safe travels. All right, do we have a planner's update?
No, other than with the ZEPSA rezoning, the public hearing was held 2 weeks ago, and council tabled the decision to their work session next week, mainly as we are finalizing the final terms of development agreement, but that vote will be next week. Other than that, that's kind of all I got, I think.
With the passing of the village, or of the Union County County Commissioner, the chair, do we see any, do we know what's happening? Are they replacing?
If Austin, you might, I'm pretty sure that they've opened that.
I believe, I don't know what they're doing yet. It's my understanding that if that vacancy becomes available so many days before an election, it has to be appointed and then go to a special election, which I think they're within that time limit. If you go past the date, it can be appointed and not filled again until the next regularly scheduled election, so.
I don't think it fell within the special election.
I'm not sure. I'm honestly not sure. That's something I don't really deal with. But.
And
It's supposed to be appointed, but I think it's you also have 2-2 or 4-person, so it's not sure.
I think, from what I was conveyed, is that they have opened applications for appointment. which I think it's it closes in a certain amount, and then the county commissioners are supposed to then vote on that appointment by, let's just say middle of September. If they cannot come to an agreement because it is a split vote on who that appointment is, then it will go, that's when it will then go to a special election, because it's still within the parameters to still be advertised. All those people who filed will then, that's from my understanding, I think that's what I was told yesterday from Joe. Is some along those parameters where their applications are open for the vacancy. The county commissioners will vote to fill that vacancy. If they cannot, quote unquote, fill that vacancy because they can't agree or whatever, then it will be on the November election.
And the municipalities in Union County don't have any representation on the council.
Every Wilson County residents, every person in the county, including in Marvin, can vote in that election.
Right, but it's not guaranteed that anyone from this area represents, it's not like a district,
All county seats are at large, meaning that there's not a ward that they're tied to or whatever.
For another,
Yep, okay.
for another time.
All right, I don't believe there were any agenda items? Or action items, sorry.
Bring your binders to the meetings.
Yeah, I forgot this time. And bring your canceled checks if you have not done so already.
I'll have to start chasing you down and showing up at your houses if you don't.
That could be convenient,
I have an accessory
though.
dwelling unit that maybe you can also rent.
Stop. All right, board member comments? Anybody want to start? All right. Yep.
Staff, thank you very much for your work, appreciate it.
Thank you for your work. John, welcome back. It's great to see you.
I'll be quiet, I'm sure, for a while until I get my.
So you get your feet under you? Yep. We expect.
I think your sea legs are already there, but
Anything from you, Will?
It's good to see John here. I don't know why he's looking for punishment, but it's good. You know.
John, anything from you besides, you'll be quiet for now? All right, then if there are no other comments.
I'm good, Kelly.
Oh, sorry, Mike, I'm so sorry. You've been so quiet. I forgot you were there. Michael Lavelle, do you have any comments? Do you have any comments before we
No,
close the meeting?
Sorry I couldn't be there tonight, everyone. I look forward to seeing you next time. John, welcome back. Can't wait to see you again, and I'll bring my binder and canceled check when I get back in town, guys. Thanks, everyone.
All right, thanks, Mike. Have a good one. All right, well, if there's nothing else, if I could get a motion to adjourn the meeting? At 8:43.
at 8:43.
Who's going to do it? John, you do it. Can I get a second?
Second.
All right, Rich seconds. All in favor?
Aye.
So
Aye.
moved. We're out.
Good night, everyone.
Good night, Mike.